Welcome to Mose Cybersecurity Institute. My name is Colin Marr and I'm the Global Account Director responsible for security solutions here within the organisation. Today we're continuing our video series on compliance and we'll be talking about the Privacy Act here in Australia. Ultimately, privacy at its very core looks to promote and protect the individual's identity, and certainly in the context of this legislation, it seeks to not only promote and protect individuals' privacy, but also it challenges organisations to question not only what information they're collecting, but how and why they're collecting that personal information about their clients. It also typically applies only to organisations that have an annual turnover of $3 million and above. However, there are important exceptions that we'll talk about shortly. It also asks you to, or provides you the opportunity to look at the information that is available about you within the public domain. And the recent My Health record is a classic example of an opportunity that you now have to look at what information is stored about you and whether that information is true and correct. So it gives you the opportunity to correct information if it's incorrect. But also it takes privacy and disclosure obligations a step further by ensuring that you have a say in who communicates with you. For instance, I think we've all been the subject of late night telephone calls with companies trying to market any number of products and services to you. And it provides you the opportunity to opt out so that you don't receive those type of calls. And it also gives you an avenue for redress in the event that you're not being, or you believe that your personal information is not being handled appropriately by organisations that operate within the Australian jurisdiction. But also, if we now look at some of the exceptions, and I think they're really important ones, and I'll just read to a couple. Obviously, any health services provider, and it covers everything from a hospital, a day surgery, your local GP, any service that involves your health and well-being are important exceptions. And it takes it a step further to even, and we may not have considered this, your local gym or even your dietitian, and any service that you consume where probably more personal information or more relevant personal information is captured about you. And there are a couple of other important exceptions, and they look at organisations that their primary business function is to capture personal information, and so that becomes their key focus as an organisation, and then they on-sell that information to third parties. So it's very important to ensure that your information is appropriately protected. And obviously any organisation that is operating with the remit of providing credit-related services fall within the jurisdiction of this legislation. And probably finally, any organisation that is undertaking or working with government agencies, either it be state or federal. And it's a fairly broad category, and it probably just highlights that when you're looking at not only conducting business in these verticals, but also thinking about what information you're capturing, it makes you reconsider not only what you're capturing but why you're capturing it, but also how you're storing that information. Because in the event that that information was leaked into the public domain, it could have serious both reputational as well as financial consequences for you as an organisation. So it's an opportunity to really rethink what information you're capturing, why are you capturing it, are you complying with the relevant domestic legislation, and also what processes do you have in place to secure and protect that information against inadvertent disclosure into the public domain. Anyway, thank you so much for listening, and I look forward to delivering the next instalment in this series.